Today I will be talking to you about the Telecommunications Act of 2023, which was recently passed by the Lok Sabha and the Rajya Sabha, and also received the presidential assent just last in late December. Through the course of this presentation, we'll be giving you a brief overview of the telecom sector in India, and we'll give you an introduction to the Act, notable highlights of the Act, the adjudicating authorities, the process of adjudication, and the penal provisions involved under the Act, some potential challenges that may surround the Act as we progress through, and some of our concluding remarks. So the reason why we required an updated law on telecom sector in India is because we are already with the pace with which we are progressing in respect to the telecom industry in India. We are already the second largest telecommunications market, right behind China. We have the third highest number of internet users in the world, and we are a very emerging global innovation hub as well. And in pursuance to the government's exercise and attempts towards ease of doing business, there have been a lot of attempts made throughout the course of this entire act to reduce the number of licenses and compliance requirements as well. So, to give you a brief introduction to the act, this was first introduced in the Lok Sabha as a bill on 18th of December. It was passed by the Lok Sabha on 20th of December and then by the Rajya Sabha on 21st of December. And on 24th of December 2023, the bill received the presidential assent, and it was thereafter called the Telecommunications Act of 2023. This act repeals three major acts: the Indian Telegraph Act 1885, the Indian Wireless Telegraphy Act of 1933, and the Telegraph Wires Unlawful Possession Act 1950. Now, some of the major and key takeaways that we thought are of utmost importance under the Act are that it reforms and simplifies the regulatory and licensing regime for telecommunication services and telecommunication consumers as well. Of course, it replaces over 100 types of licenses with authorization, which is focused on three aspects: providing telecommunication services, operating and expanding telecommunication, and of course, possession of radio equipment for providing these telecommunication services. It also allows the government to take control over these services from time to time as it may deem fit and for in the interest of national security and interests. And it also provides a non-auction route for certain telecommunication services for allotment of spectrum as well. Uh, yeah. So we have distributed the key highlights of the act under five heads: the government authorization, the protective measures laid down under the act, the regulatory measures laid down under the act, the adjudication process introduced, and the penal provisions under the act for non-compliance of the provisions. So we move on with government authorization as laid out under the act. Now, in this case, all communication services or all telecommunication service providers have to seek government authorization to carry out their operations in India. And in case of provision of telecommunication service without any authorization from the government, can lead to an imprisonment for a term which may extend to 3 years, or a fine which may even extend to 2 crore rupees, or both. Now, broadly, telecommunication services have been distributed into five heads, and these are telecommunication service providers establishing, operating, maintaining, or expanding telecommunication networks, possessing radio equipment, permission to carry out mergers and demergers, and biometric identification for telecom service users. Now, apart from that, the government authorization is also required for assignment of spectrum. So under the new act, under the Telecommunications Act of 2023, the central government shall assign spectrum for telecommunications only through auction, except for certain exceptional cases, which are laid down here: national security and defense research work, disaster management, weather forecasting, transport, satellite services, and for the PSUs, that are BSNL, MTNL, and other public broadcasting services, where the government shall distribute the spectrum on an administrative basis. Now, one of the most controversial aspects of the act is the power that has been granted to the government with respect to interception, search, and surveillance. Now, under the provisions of the Act, specifically Section 20 and 19 of the Act, the government is empowered to intercept any message or class of messages to or from any person or class of persons and disclose in intelligible format to officers concerned in the case of public emergency, in the interest of public safety, and so on and so forth. So basically, what has happened is that a very broad criteria has been laid out for to allow the government to intercept and to create a mass surveillance program and to search any kind of messages that may be transmitted between persons or classes of persons. Now, it has also been empowered with emergency provisions as well, the government here, and it states that in case of any public emergency, including, of course, disaster management or in the interest of public safety, so here both the central government as well as the state governments are empowered to to do the following: to take possession of the telecommunication service, to provide for an appropriate mechanism to ensure that public emergency responses are provided, and to also direct that any telecommunication service or class of telecommunication service be suspended. So it also, this, as an emergency provision, the government also has the power to suspend telecommunication services, as was also provided under the Telegraph Act. Now we move on to the protective measures. So, of course, the Telecommunications Act also provides for a lot of protective measures to protect the identity and also take control over the kind of frauds and spam messages that have been going on in the recent age. And in this regard, in fact, there has been a specific provision laid out with respect to protection from spam messages. Now, under the new act, there is a prior consent that is required from the users, from the end users, for receiving such messages, and also a preparation or a maintenance of a DND register has also been mandated to ensure that users who have opted into this DND platform do not receive any spam messages without their prior consent. It is the Telecommunications Act also restricts impersonation and has called for very strict penal provisions in this regard. It states very clearly that any person who fraudulently uses any other person's government ID to procure a SIM card will face imprisonment up to 3 years and a maximum penalty of rupees 50 lakh or both. There is also a very strong verification process that has also been incorporated into the act, wherein the SIM cards will be provided to the end consumers only upon provision of a biometric based identification, such as Aadhaar card majorly. Now, this as per the government is a major attempt to boost or to reduce, in fact, identity theft and fraud that take place using fake identity cards. It also calls for an establishment of an ODR mechanism, basically. And every authorized entity, in fact, that is the telecommunication service provider, must participate in the dispute resolution mechanism and must comply with the terms and conditions as may be prescribed under the rules which will follow. Now we come to the regulatory measures that have been introduced. First of all, very clearly now the government through the act has provided right of way to the telecommunication service providers, and it states very clearly that entities that lay down telecommunication infrastructure may seek right of way over public or private property, and it shall be provided on a non-discriminatory and non-exclusive basis to the maximum extent possible. Again, under the they have also made some other changes with respect to the constitution of the or in fact the eligibility of the chairperson and the members of the tribe. For the appointment of the chairperson, the candidate should have at least 30 years and 25 years for members. Apart from that, it has also retained the Universal Service Obligation Fund. This fund was basically used to bring in telecommunication service to the more remoter areas in India. However, this particular fund has now been renamed as Digital Bharat Nidhi. Now we move on to the adjudicating authorities that have been and the adjudication process that has been laid down under the Act. So there is a four-tier dispute resolution mechanism. First, of course, is a voluntary undertaking that has to be provided by every telecommunication service provider. Then we have the adjudicating officer. We have a designated committee of appeals, and then we have the TDSAT. Now, if you can also bring in a similarity from the data protection board that has been established under the DPDP Act, where the AO and the DAC will, as far as possible, be online. So the entire process of adjudication has been proposed to be online. So the adjudication process requires, first of all, an adjudicating officer who is an officer of the central government and not below the rank of joint secretary. And after the inquiry, the adjudicating officer, of course, has the power to pass a written order for consideration of the government, and then the government passes an order. And what are the penal provisions? We'll also get to that in the later stages of the presentation. And at the appellate stage, we have the designated appeals committee, which of course is again by members of the central government, which states that which shall have all of these members of the designated appeals committee shall not be below the rank of additional secretary, and any other person aggrieved by an order made by the adjudicating officer can file an appeal within the committee within 30 days from the date of receipt of the order from the adjudicating officer. Now we look at the penal provisions. We have distributed the penal provisions in two heads. First of all, penalties with respect to non-compliance with the terms and conditions of the authorization and assignment of spectrum, and non-compliance with other provisions of the Act. So when you look at non-compliance with respect to the terms and conditions as laid down in the assignment of spectrum, the adjudicating officer can pass an order, and he can either direct penalty, or he can direct the service provider to abstain from doing any act that is committing the breach, or they may ask them to change their ways to ensure compliance. Now, when we talk about the direct penalties, they have laid down different severities, basically, for against which there are different amounts of penalties. As we can see here, severe, it goes up to rupees 5 crore, and for non-severe warnings, the adjudicating officer just issues a written warning to that service provider. Now, it has been stated very clearly under the Act that non-compliance with the terms and conditions of the assignment, for which no specific penalty has been otherwise been provided, can result in a penalty of 25,000 on the first offense and 50,000 per day on subsequent offenses. Now, in cases of non-compliance, the adjudicating officer, where the adjudicating officer has reasonable grounds to believe that non-compliance has taken place, it first issues a notice to the offending party, and thereafter the offending party may submit an undertaking stating that it is taking mitigation measures, and the changes it proposes to take in respect of the non-compliance. And these voluntary undertakings shall be considered to be the mitigating measures that may be considered for the purpose of determining the penalty that may be levied by the adjudicating officer. In case of non-compliance with the other provisions of the Act, these inquiries can either be done on the basis of receipt of a complaint, or it can also be conducted suo motu by the adjudicating officer. The penalties would also be the same for those parties who are also involved in abetment, attempting, or conspiracy, just as they apply to the actual non-compliant members or service providers. Now, the penalties that are covered here are, first of all, used by any person or entity of a telecommunication service, knowing or having reason to believe that such service does not have the required authorization under the Act. So if a person uses a telecommunication service, having knowledge of the fact, or having reason to believe that such service was not authorized by the government, they shall be liable for a penalty up to 10 lakh rupees. And whereas non-compliance with the user protections, as we laid out before in our protective heads, can lead to attract a penalty of rupees 50,000 rupees for the first offense, and every subsequent instance of non-compliance can result in a fine of rupees 2 lakhs or suspension of the telecommunication service authorization or a combination thereof. Now, what happens when you have received an order from the adjudicating officer? You proceed on appeal. Now, here again, the appeal has also been distributed into two. The provisions for appeal has also been distributed into two. For cases of non-compliance with the terms and conditions of authorization and assignment of spectrum, you can directly approach the TD Act within 30 days of receipt of the order. And for any other non-compliance of the provisions of the Act, you can go, in fact, after the designated appeal, after you approach the DAC or the designated appeals committee, you can approach any civil court having jurisdiction over the matter, but no civil court shall have jurisdiction in respect to any matter where the adjudicating officer, the DAC, the central government, or the TD Act are empowered to determine. Now we look at some of the challenges or the potential challenges surrounding the act, because this is an act that empowers the government to surveil or intercept messages. There are a lot of potential challenges that may come up in times going forward. We have distributed them into certain heads: administrative abuse, threats to user privacy, definitional ambiguities, excessive executive control, and unreasonable penalties. Administrative abuse, here we are directly talking about the fact that the government in this case, with respect to surveillance, have been given wide and very broad powers under the garb of public emergency and public order and defense and security of the state, which have no specific import, and therefore for any n number of purposes under section 20 and section 19 as well, in fact, can the central government or the state government intercept or surveil any kind of messages that you also may send on WhatsApp or a Signal or Telegram and so on and so forth. Now, the other problem that we also face under the Act is with respect to the definitional ambiguities, in fact, which I would like to point out in this instance itself, because when we look at the definitions that have been provided under the Act, specifically with respect to the definition of telecommunication and the definition of message. I'll just read this out for you. Telecommunication under section 2P means transmission, emission, or reception of any messages by wire, radio, optical, or any electromagnetic systems, whether or not messages have been subjected to rearrangement, computation, or processes by any means. Now, messages as laid out under the definition of telecommunication is also defined under section 2G of the Act, which says that message means any sign, signal, writing, text, image, sound, video, data stream, intelligence, or information sent through telecommunication. So the broad criteria laid down under the definition of the Act with respect to telecommunication service and messaging all clearly lays out that even internet services would come under the ambit of telecommunication services, and therefore would also be liable for surveillance and interception by central government or the state government for certain reasons, as have already been stated. Apart from that, of course, there is also a threat to the user's privacy, as we have already seen by the Supreme Court has already laid down that mandatory linking of mobile numbers with the Aadhaar card is unconstitutional. Whereas under the present Act, it has stated in very clear terms that verifiable biometric based identification has to be mandatorily used prior to issuance of SIM cards by all parties, by all service providers, telecommunication service providers. So this again might be a challenge or a threat, and might go against the order of the Honorable Supreme Court in this regard as well. Apart from that, we also note that there is a very excessive executive control, because all the adjudicating authorities, the appellate process, are all entirely managed by the central government. And it has also been given, and the central government, as I've already stated, has also been given broad powers to intercept, detain, disclose, or suspend any message or class of messages, and to direct suspension of any telecommunication service or class of telecommunication. And apart from that, the penalties that have been imposed or the under the act has also been is also very unreasonable, because especially with respect to users who are using telecommunication networks, either knowingly or having reason to believe that it is unauthorized. So previously, under the Telegraph Act, the penalty for such unauthorized use was rupees 50. It was then increased to 1 lakh rupees under the Telecom Bill of last year in 2022, and to a hefty 10 lakh rupees now under the Telecom Act 2023, as has been laid down under the third schedule. In fact, so it is a very broad criteria, because the statement having reason to believe so may be used in a very different context or in a very broad context by the government or by the adjudicating officers who may impose such penalties on users. So, concluding remarks. So, while the government, of course, has taken enormous steps and appreciable steps with respect to allowing or reducing the number of license and compliance requirements under the Act from about 100 license requirements to only 3 license requirements now. There are also certain ambiguities that have not yet been clarified, which may have the potential of being clarified after the rules come into picture. As of now, as has been laid under the Act, the rules as laid down under the Indian Telegraph Act are still going to be valid with respect to the provisions that have already been provided under the Act. So this would be the this is the overview that we have taken of the Indian Telecommunications Act. I would be very happy to take in questions as well if you have any. Thank you.